Hello and welcome. Thank you for watching. This will be the first video in a legal infotainment series known as Tang and Tate. This video is about how to form a will, how to make one, why you need one, how to make one valid. And on this first video, we have two special guests. We have Cynthia Chandler out in the Bay Area in the West Coast, San Francisco. And then we have Shannon she's an expat over in Bangkok, and she is not an attorney. Cynthia is, along with Kat and I. Shannon is here to kind of ask questions and clear up anything that might sound confusing about how to make a will. I'll throw it over to Catherine Tang now.
Hi, I'm Catherine Tang. I'm an attorney licensed in California. I run a virtual practice, and today we're going to go over the different kinds of wills and especially things that you may want to watch out for if you're not hiring an attorney and you want to look into other options.
And there's a lot of important stuff on this video. In terms of why you need a will, if you do not form a will, a lot of people wonder what happens. If you do not form a will, it is known as dying intestate, without a will. And that means your assets and anything you own, it goes according to state law and state statutes about how it flows down to your kids and anyone you're related to. So if you want to make sure where your bank accounts go, where your personal assets go, any cars, anything you own, tangible, intangible property, you're going to want to make a will. In that way, it's very clear what happens. If you do make a will, you are known as the testator. So these are a few key terminologies. If you die without a will, it's known as dying intestate. But if you make a will, you're known as the testator. When you do form a will, you're going to want to list very clearly how your assets are divided. And that includes intangible property, such as books that are copyrighted by you, or even all the tangible property, cars, bank accounts, things like that. And you also want to include the personal representative that after you pass away, that is the individual who will help divide your assets. Now, Catherine Tang is going to kind of tell you the types of wills. You got the holographic will, and then you have the standard attested will that most people kind of think about.
Okay, so we have the attested will, and the way you can make an attested will, I think obviously the best thing you could do if you have the time and money is to hire an attorney who's going to make sure that you do it properly. However, we understand that not everyone can do this. So there are other options, such as in about half of the states in the US, you can do a holographic will. And what a holographic will is it's a handwritten will. It usually requires you to write the entire will in your handwriting and for you to sign it. And you can do this as the simplest, quickest way to do a will because there are very few requirements. You don't need to have a witness. You just write down your wishes on your paper. But when you're doing this, you need to be careful not to be ambiguous. This is one of the biggest reasons why you would want to hire an attorney, because we can draft things in a way where there's no argument afterwards, right? Some of the other options that you have are some of the online services. Like online wills, they can be cheaper. The problem with online wills and using something like LegalZoom is that they don't actually give you legal advice. You kind of tell it what to do and they'll draft it for you, but you don't know if you're actually drafting it correctly or if it's even legal.
That's right. So a lot of times when you see a will maker online, they're kind of walking you through a questionnaire or some type of form that asks you some questions. You might put some custom information, and then you're printing it out, and then you're finding witnesses to sign it. That's for the standard attested will that we're talking about. But a lot of the time, sometimes the online services, they might not accurately reflect what you want, which is why sometimes almost nearly all the time, it's important to kind of find trusted counsel, a local attorney or someone or an attorney that a friend uses that you can kind of rely on to accurately reflect your wishes in a will.
But we understand that during this time, there's a lot of people that are very worried. They've never had to think about their own mortality and putting their wishes down onto a will. So if you are, scared and you're quarantined, what you can do is just get a will down now. We call this a stopgap measure. You have something down now because having something down is still better than having nothing down. And then later, if you have more time, then you can hire an attorney to do it properly. And you can do it by either having a codicil, which just amends your existing will and adds other terms or changes a few things, or just have an entirely new will drafted.
Yeah, so even in this time period, in many states, people are asking, well, I'm quarantined. Can I just have someone do an electronic signature? As of right now, only Nevada and I think Nevada and Indiana allow digital wills to be created, which is you're creating the will online, people are digitally signing it. And it's just similar to how Virginia is the only state right now that allows online notaries. So it's still very important right now to understand that when you make a will online, you still need to ensure by looking into what your state allows, because every state is pretty much different, making sure that that will is actually valid. Because if you pass away and there's ambiguity on whether you have a valid will, it can be a total nightmare. People can claim things of your possessions that you never were going to leave to them, or it could just be a total disaster for close family that wish that you left things accurately represented for what happens later.
Can I add something in? So my name's Cynthia Chandler. I'm here because I'm also an attorney. I'm an attorney licensed in California, and I run the Bay Area Legal Incubator, which is a community of lawyers, all trying to provide affordable representation to folks in California. One of the things that's really important to think about with getting witnesses, if your state is requiring witnesses, you're not doing a holographic will, is to remember that the reason for those witnesses is that you need people that can vouch that your wishes really were your wishes if it was ever challenged. So when you're picking a witness and you're thinking about who would be signing on to your will and saying that you did it, you also want to imagine who might be willing to stand up and be a witness in court for you. So you want to have a sense of like who that person is that person reliable? Do you know who that person is? And even in this age when so many of us are sequestered in home and can't get away to go find our best friend across town or whatever, even if you were to use your neighbor as a witness and literally shuffle pieces of paper between you and always staying 6 feet or more apart, you could identify people who could be legitimate witnesses. But again, you want to make sure to the best that you can that you're picking people who are reliable. And if you can't pick people who are reliable, that would be one of the times where you would really think about doing the holographic will.
I think also what people are doing during this time is that I see a lot of attorneys doing car signings. So you may have the attorney there in one car, you have the testator in their car, and then you have the witnesses outside so they can see you signing that will and attest to that. Mm-hmm. And you can still maintain the social distancing. And I think that there's a sense of urgency when it comes to writing a will because we're all in lockdown, we're all, may or may not be in quarantine, but you want to get your wishes down before you're on an incubator. Cynthia, could you go over some competency issues?
Sure. So, again, with any kind of will, what the courts and parties are going to be interested in is, were you actually in a good state of mind to actually make these decisions? So if you give everything to your sister Flo and you leave out your son Jeff, Jeff might say, was this really real, or who pushed the person into doing that? Some of the competency issues that can commonly come up are things like, who really wrote this form will using one of these software programs? Was it really the person who was sick or ill, or was it really one of their children? And did they actually fill it out in order to leave out another child, or to leave something precious to them and not to somebody else? And that's when competency becomes really important. If you yourself are drafting a will, you want to make sure that there's no doubt that this is what you wanted, that you are in sound mind and body to do this. And certainly if someone is needing to be incubated or intubated, they're going to be sedated. They're not going to be able to communicate. that is not a moment where anyone would be considered to be in sound mind and body in order to sign off on a will. And even if someone has limited oxygen, that can create cognitive issues, that can create decision-making problems. So again, you don't want to leave these things to too much at the last minute, because it really could be readily challenged. Additionally, if you're in the hospital, there can be, in some states, and this is something really important to look at, there can be limitations on who's allowed to be a witness. Frequently, medical providers themselves cannot be witnesses. And if you're isolated in a hospital room and the only people around you are medical providers, that could be, again, a real problem for finding witnesses. And the reason it's a problem for witnesses is because there's this question of, did you really have competency, or were you manipulated by someone who you are dependent on for care, telling you you have to sign something or not sign something in that moment?
Yeah, and kind of
Can I ask
touching
a
on.
question?
Oh, yeah, go ahead.
Yeah.
Go ahead, Shannon.
Oh, hi. Can you hear me?
Yes.
Yeah, I just wanted to ask. So if I wanted, my name's Shannon. I'm not a lawyer like everyone else. I just have a couple of basic questions. So if I decided to get an attested will done, can you give me an idea on how long that usually takes and what the average cost is through an attorney?
It depends on several factors. It depends on how complicated your assets are. How many homes do you have? How many bank accounts? Whether you have children, whether you're married. A lot of attorneys, and I mean, I don't know what everyone charges. There's obviously a range, but I do know some people charge about $1,000 for a basic will, and like maybe 50% or 100% more than that if they're married, and depending on their children. And then you also have to think about what's important that we haven't mentioned yet is that wills do not bypass probate. And that's something very important. If you have children or if you're looking to bypass probate, you want to get a trust. And that's going to cost more than that.
So Kat, for the unfamiliar, explain probate for the unfamiliar real quickly.
Okay, so basically when you pass, your assets, right, go before the government. It goes before a probate court. And the probate court is going to determine who are the proper recipients of your assets. And this generally takes a lot of time and money, and it's something that we try to avoid however possible, because it can hold up your assets where no one can touch it for like up to a year or more. And you're going to have to pay the probate court in order to administer your estate. And in the state of California, this cost, I believe it starts at $4,000 for an estate of about $100,000 in value, and goes up to $200,000 or more if you've got $25 million. And it can take years. So if you go through an attorney, they're going to help you draft it so that your assets never have to go through the court. You never have to have someone telling you what to do with this money or who is supposed to be getting what. You can just name someone to do it yourself.
That's right. And, kind of touching on that, because we covered a lot of ground here about why you need a will, what should go in a will, how to make a will valid, different types of wills. And this is the impetus for this video was the fact that there's such a surge and boom in making wills with the coronavirus and COVID-19 kind of backdrop here. And even though people are quarantined, there's still the question of, well, what if I make a will in Texas? Is it valid in Nebraska? What if I make a will in Georgia? Is it valid in Florida? Every state's different. Generally, sometimes if you make a will validly in one state, it can then be valid in the state that you're moving to. That's less of an issue right now because we're all kind of stuck at home. You're not moving across the country. I hope you're not right now, but that's also a question that does come up.
A question that I also get a lot is like, can I do a video will? Like if I just shoot a video and I tell people what I want, is that going to be valid? Or if I send an email, is that going to be evidence? And generally, I think that holographic wills are the only ones that are actually valid by law in some of the states. There's no such thing as a video will or an email will at this time.
I will add to that, though, that if you're doing a holographic will and you have access to technology where you can film yourself doing it, why not? If you think that there might be someone in your family that would contest what your wishes are, why not just film yourself doing it? Film yourself having a conversation about your intentions behind it. Create that actual evidence of your own sound mind in that moment and your real intentions. It does not replace the will itself. And you certainly would want to make sure that you're providing consistent information in the document as you are on the video, that they match. But you know, similarly, if you're using witnesses, you could film the witnesses signing what they're doing. There's no reason that couldn't be done. And you know, for all these things, if you're doing something on your own, if you're using a template, there's no reason you can't also check in with an attorney and do like a phone coaching session, even in this moment, if you're nervous about going into an attorney's office. You could get some pointers on things that you could include on a holographic will for yourself. You could get some pointers on things that you might want to amend in a template will that you got offline. And you also could even, you know, if you were doing some kind of virtual thing of documenting what you're doing, you could even record that. I wouldn't record a conversation with an attorney, but if you were having a group of people witness you even doing it through Zoom, like say right now I was writing my own will and I'm like, hey, everybody, you're all watching me do my own will. We're documenting it. It's all the more proof. You could invite the attorney along if you want to pay someone to do that. The more proof you have that you're in sound mind and body to do this, and these are really your intentions, all the better.
I wanted to point out some of the things that you want to watch out for while you're writing your will. Number one, I had already mentioned this, is to try to avoid ambiguities. So if you're saying, I want to leave all my money to my friend Jack, maybe specify which Jack this is. Is it Jack Smith? Is it Jack Tang? Whatever. Try to maybe even add in their driver license number or something where someone else with the same name can't argue that. Or if you say, I want to leave everything to my sister, and then it turns out you had a sister that you've never heard of, or you had multiple sisters, I don't know. Try to be as specific as possible. You also want to mention the things that the people that you specifically do not want to leave anything to. Because some of these people may come back later and say, oh, they just forgot about me, right? If you maybe have an ex-husband or an ex-wife or children or just anyone that you think may stake a claim into your assets, you want to specifically go in there and write, I'm specifically leaving out this person from my will.
I would say that is an area where you also could really benefit from getting some coaching. So it could make it really affordable and easy if you're writing your own will to just say to an attorney, hey, you know, I have one child, for example, that I've given a lot of money to during my life and another child who I've never given any money to. And I want to make a disproportionate bequest to the person the child I haven't given so much to during their lifetime. Or maybe one child has some special needs that means that they need more assistance in life, and so you're actually going to give them more after you pass than the other child. Those things can raise red flags around challenging a will, because it seems unfair, unequitable, unless it's actually justified and explained. And that would be something that would make a lot of sense to get. Literally even a 15-minute consult with an attorney on how to draft it so that you can do it right, get your intentions done correctly, and proffer the right kind of proof in the document that makes it seem reasonable to the average person reading it.
And those of you watching from California, Bali does have a website, right? That will help. If you go to this website, it'll connect you with an attorney that may be able to offer you coaching.
Sure, it's Bay Area Legal Incubator.org. Yeah, you can click the tab on asking for help and we can connect you to attorneys in the area who can assist you in an affordable level.
Yeah, and Bali's a great program where if you are low income or you don't meet a certain threshold, there's a lot of attorneys that will help you out at a lower rate.
A lot of people have their whole practice around providing affordable representation. Other folks have sliding scales, whatever it is. But at any rate, there's a lot of attorneys out there, increasingly so, who want to fill that market gap and provide affordable representation.
Yes. One of the things that once you've written this will, what you might want to consider is to put it in a safe place. Maybe make a copy of it, give it to someone else so you have a copy of it somewhere else in case your house burns down or whatever. Make sure that other people know where your will is so that they can find it easily afterwards and they know that one exists.
Make sure it's dated, right? It needs to be dated. And one of the reasons it needs to be dated is later on you might change your mind. And if you have this holographic will floating out there in the world and someone else has a copy of it, and then later you write something different, you want people to know what the most contemporary version of your wishes are.
Yeah. One thing that I do notice that people need to pay attention to that not a lot of people have talked about is digital assets. You want to leave access or maybe put your logins and passwords to someone because there are a lot of people where they had someone in their family die and they can't access like their digital photos or their Facebook or their LinkedIn or their emails to get access to all these informations or even to suspend the account. That I know has really been a problem for a lot of people. So you'll want to write that into your will as well.
Back in the law school in the Trust and Estates Clinic, my project was on digital assets. And I created like a booklet of everything under the sun where you can put your emails, your bank accounts, things like that. You want to basically catalog every online account that's important. And then your will explain who's assigned what. We've covered a lot of ground in this video. A lot of times when you watch movies or read books, you hear deathbed utterances and things about how right before someone dies, they say, hey, take this. But how you divide your assets after you're done here is a much more formal process and based on how the states and courts are going to look at things.
Okay. Cynthia, are there certain things that you want to mention about if you have something that's complicated about your assets? These are scenarios where you do not want to attempt to try to make your own will, and you definitely should seek counsel.
Well, or let me sort of phrase it slightly differently. I think there's a lot of scenarios where you might definitely want to get coaching at the very least, right? Some really common situations, again, so that you can write it in a way proactively considering these things and not make maybe matters even worse by having a will. Some common scenarios, and this is not an all-inclusive list for sure, some common scenarios might be if you have a child who requires public benefits, maybe for a medical condition, you want to get some help in framing how you're leaving assets to that child so that they're not financially disqualified from getting that assistance. And there's ways to create special needs trusts and to do things and to shelter those assets so that a child could still continue to get the care that they need and not be disqualified from that while also having some access to the money that's been given to them. That would be one area. Another area is if you know you have children who are fighting. They always fight. They fight over everything. I think it would be very important to seek legal counsel to figure out how to deal with a situation like that. If you know you have children who feud over almost anything and everything, so that you can have a level of peace of mind that you've done everything you can do to help reduce possible complications and feuding in the future, and that you give your children the best shot at having a better relationship into the future.
Shannon, did you have any questions that came into mind during this?
Yes, I wanted to ask if you are separated from your spouse, but you have children together. What if you can't decide on godparents or something very important like that? Okay.
So in wills, typically you can state your wishes as to who would care for a child in the event that you pass away. Those wishes are not always binding, and that's something where, again, this is an issue where I would strongly recommend you get advice from counsel on how to craft it, how to write it, so that your wishes might have the most weight. Right? And certainly just on a practical level, if you have children with someone who you're no longer in a relationship with, and even if you are still in a relationship with them, that is something to talk over with that co-parent, what those plans may be for the children. The more consistency that you have while you're alive and the more agreement that you have while you're alive, it makes it easier to both put that in writing, it also reduces the chance that your children are going to be in limbo later if you pass away, because there's, you know, a lot of feuding over that issue and who would have guardianship over the children.
Okay. I think my only other question was just sort of a general one. You went over a lot of potential pitfalls, like making sure to date your holographic will and have a different, have extra copies of it. Would you say there are any other things to look out for or common mistakes that people make?
Catherine, maybe you could run down the list of what a holographic will has to have in it one more time.
Okay. So you should actually date all of your wills, whether they're holographic or not. But in the state of California, which allows holographic wills, you want it written in your own handwriting. You need that document to identify that this is a will. So usually you use language like this document has testamentary intent. You want to sign it with your usual signature. And that's basically the minimum requirements. But some of the things you want to add are the date, your full name and address, maybe the full name and address of anyone that you're leaving things to, and you'll want to have witnesses that watch you sign your will, if possible.
Yeah, and remember, not all states allow as valid a holographic will. For example, California does, Florida does not.
So
Okay.
you'll want to double check with an
Always-
attorney and state
always-
about what's valid or what's not.
Yes, before you make a will that you want valid, always check with your state on what it allows as a valid will.
Okay.
I think that if you have minor children too, you should look into getting an attorney and having a trust set up for the children. Because if you were to pass before they reach majority age, there could be a lot of complications.
Mm-hmm.
Yeah, there's a number of times where you really, I mean, there are different situations where people need to write wills, right? Some can be very urgent and there's a sudden need to really write something down. I had a cousin, for example, who in her 30s was suddenly diagnosed with a very serious form of cancer and had 24 hours notice after being diagnosed that she was going to have to go into major surgery, and she had 2 small children. So she literally found out this very unexpected diagnosis and then had 24 hours to prepare, and didn't know if she might not survive through that operation, right? So that was an extremely urgent moment where she did not have the time with everything she had to get set in place, including preparing her children for what was happening. She didn't have time to go to a lawyer's office, right? So she did the best that she could in that moment. She used a template will. She had me as a cousin, so I hooked her up with a trust and estate attorney who had like a 15-20-minute conversation with her on the phone about any extra provisions she may or may not use in that template will. And she went with it, right? And she revised it about 2 months later, when she was, you know, through that surgery, when she had recovered a little bit, you know, and did that. And then at that time, it became really clear that actually she should create a trust and she should do some things in a more complex manner, also so she could avoid probate, which we talked about the costs. So I think, you know, if it's possible, it makes sense to at minimum get a consultation with an attorney, find out if you should do a trust, find out if there's special things that you need to do to help shield or assist certain people in your life you might be giving money to, protect your wishes. But if that's not possible, you have to make a cost-benefit analysis of whether or not you need something rather than nothing in that moment.
Yep. So again, these are what we would call stopgap measures. I think that what we're recommending right now for everyone affected or afraid of coronavirus is a stopgap measure. It's something just for now. And as soon as you are able to, find an attorney to draft it properly for you and actually do some estate planning.
Okay, thank you.
All right. Thank you, everyone. I mean, I think, did we go over everything, Mike? Is there anything else?
Yeah, we covered a lot of ground. We hope you found this video very helpful. It's the first video in our new series. So thanks for tuning in, and thank you, Cynthia and Shannon, for joining along for the fun.
Thanks for having us.
You're welcome. Thank you.